think Sharon Roush is a court reporter. Does that sound familiar to you?
I think so.
I'll let her in first. Good afternoon. This is Magistrate Bocelli. I've let in, I believe it's Sharon Roush. If you could unmute yourself and state your appearance for the record, please.
Good afternoon. I'm Sharon Roush, the court reporter from Ryan Reporting on behalf of the third party, Castilla.
All right, Ryan, R-Y-A-N, Ryan Reporting.
R-Y-A-N, yes.
And what city is that out of?
Melbourne, Florida.
Thank you very much. Are you ready for me to go ahead and let in the attorneys?
Yes.
Okay, I will do that now.
Thank you. Usually it states that I am a court reporter there. But...
Yeah, I thought I recognized your name, but I wasn't sure, so that's why I let you in first.
Thank you.
We still have one person connecting. If you all could just bear with us a moment while everyone gets connected. All right, it looks like everyone's connected. We're here in 19 CA 3104 SFR Services LLC versus Tower Hill Prime Insurance Company. We have Sharon Roush from Ryan Reporting as our court reporter today, and she'll have the, oh, do we have two court reporters? Okay, I always think it looks like we have Christy Davis as well.
Yes.
Well, I don't know what y'all want to do. I don't know who ordered. What's your preference?
Who's here for defendant? I'm not sure which one's which.
Let me check.
I would assume it's Miss Davis. I believe Miss Roush is from Ryan. That's usually ours.
Yes, I'm here for Gordon Boutweiser.
Okay.
Who set the hearing? It's usually don't we go by who set the hearing? No.
Yes, ma'am.
I believe it was the non-party that set the hearing.
I'm set by a third party. I don't know if anybody else has the actual plaintiff or defendant.
Tower Hill, if anyone's set for Tower Hill, that would be me.
The notice of hearing was signed by Chartwell Law.
Nope, I think you must. You're probably on the one we have this afternoon. This one was filed by our office.
Oh wait, hold on. I'm sorry.
I think I've got another one with you this afternoon, possibly, which was with Chartwell.
Okay, I just saw May. I guess there was one this morning. That's what I was looking at. Sorry. Am I in the wrong case? I think I'm in the wrong case. That would be helpful. Hold on a second.
Do you need the case number?
No, I have it. I hadn't closed the file from my last hearing this morning, so that's my mistake. I apologize.
No problem.
The 1 o'clock hearing. Yes, it was Aaron Thowlitzer. That's the plaintiff, right? No, that's the third party. So which company was that?
Castilla Roofing.
All right, no, but I meant which court reporting company is that?
Oh, I'm sorry. That would be Miss Roush.
So I think that means we'll excuse Miss Davis and let her go about her business. Thank you, Miss Davis. I hope you have a great day.
Judge, I have you also at 1:15, so I'll see you in a few minutes.
I don't have anything on my calendar at 1:15.
David Slawpower versus Tower Hill.
We received a cancellation notice, so it's been removed from my docket. I don't know who canceled it. You might want to follow up on that, but as far as I'm concerned, there's no 1:15.
Okay, wonderful. Thank you.
All right, have a great day.
You too.
All right, we do have one other person in the waiting room though, so I will let them in. I did want to note that this is being live streamed to YouTube in order to maintain public access to the court, so please keep that in mind. I've just let in another participant. Let's get appearances from who we do have, starting with plaintiff. Counsel for plaintiff. Do we have a counsel for plaintiff here?
Yes, good afternoon. On the SFR Patullo case, I'm counsel for plaintiff.
This is the 19 CA 3104.
Yes, it is.
All right, and it's Jennifer Jimenez.
Yes, it is.
Thank you very much. And then for the defense?
Colleen Crocco on behalf of Tower Hill Prime Insurance. Good afternoon, Your Honor.
Good afternoon. And then on behalf of the non-party?
Yes, Justin Falatek on behalf of Castilla Roofing.
Thank you. Mr. Falatek. And then I also see a Christopher Hewitt. What's your relationship?
Mr. Hewitt's with my office. He's just observing, Your Honor.
Okay, thank you very much. So we, I think I already said we have Sharon Roush of Ryan reporting as our court reporter today. She'll have the official record of our proceeding. We're here on non-party Castilla Roofing's motion for protective order filed March 9, 2021. The order of referral was April 28th, 2021. I will turn it over to non-parties counsel for argument.
Yes, Your Honor. This motion for protective order follows a subpoena dus tecum without deposition issued by defendant Tower Hill Prime Insurance Company to my client, Castilla Roofing. It was served on January 28, 2021 for a production required on or before 2/10/2021. Essentially, the records requested regard a variety of records concerning a property which is at issue in this case, I believe for an insurance dispute. My client Castilla did do work at the property. We've produced documents, I believe. The issue is the scope of the documents and the request itself. The documents that we object to or production are essentially those documents which evidence financial amounts and disclosures that would essentially are trade secret and protected under Florida law. Well, and before I get to that portion of it, the subpoena itself is ineffective on its face in that it's untimely served, only providing 15 days of time to respond to a subpoena from the start is, again, to be honest with you, there's no case law directly on point regarding non-party subpoenas, but in general, when you look at subpoenas and responding to subpoenas, it usually refers back to the rules of civil procedure, and that even the rules of civil procedure give a party 30 days to respond. So a subpoena which doesn't give you that essentially would deny or is improperly served. But moving to the actual merits of the objections themselves, what the main issue is here is the documents that are created or that are requested are both not reasonably calculated to lead to the discovery of admissible evidence. The production of them would also prejudice Castilla Roofing as a third party in that it would require the production of documents which disclose trade secret and proprietary information regarding how much Castilla charges, how much Castilla actually has to pay in order to generate and create a roof at a property. So the first part of that is that it's not reasonably calculated to discovery admissible evidence. The question is, why would this information be relevant, or why would this information be reasonably calculated to lead to discovery admissible evidence? Well, I'm not a party to this lawsuit. I'm assuming what counsel would argue is that it shows what the actual cost of the roofing system was as far as what it cost to actually produce. The issue with that, Your Honor, is that the cost of production is not necessarily, or is not even evidence of what the cost of an insurance company or anyone else would owe under a policy. A policy requires the payment of replacement cost value or actual cash value, and then replacement cost after work is done. Either way, replacement cost value is generally synonymous with fair market value. It's not synonymous with what it costs a contractor or a subcontractor to actually do the work at a property. Essentially, to make it simple, it's almost as if you're going into a McDonald's and say, I'd like to order a cheeseburger, and they say, when you say, how much does this cheeseburger cost? When they say $2, they say, well, how much do you spend for your lettuce? How much do you spend for your bread? How much do you spend for your beef? And that's not really the case. When we're looking at an insurance policy, it's in terms of what the fair market value is, and that is what it would actually cost somebody to pay for, that is an insured or someone else to purchase that roofing system. And really, and it's outlined in, I believe, paragraph 7 of the MPO. It talks about a market cost approach versus, or I'm sorry, a market approach versus a cost approach. And simply put, there's no case law, there's nothing in support that a cost approach is the proper valuation for assessing what it is that is owed under an insurance policy. And case law on that issue actually supports our side also, in that when you're talking about what a insurance carrier is required to indemnify for, they're required to indemnify the insured for what the loss is. They're not required to indemnify a contractor or anyone else for what their out-of-pocket was. It's just, that would be done in every single case. We know that that's not done in every case. The only time we ever see this argument brought up, that a subcontractor's invoices or an arrangement between a contractor and a subcontractor is germane to the issues of what the value of a loss is, or what should be presented to a jury as far as damages may be, are in these assignment of benefit cases. And the issue there is, and I'm sure it'll be argued, well, the contractor stands in the shoes of the insured, and that's in terms of the rights of what the insured has. It doesn't change what those rights are. The right of the insured is to be indemnified for the fair market value of the work to be done on the property, not for what their contractor would have paid, or in this case, when SFR steps in, or whoever else steps in, and Castilla is doing the work for SFR in this case, what Castilla's out-of-pocket was, whatever they went out and paid for at Home Depot or ABC or whatever other distributor in order to procure the costs or the materials to do the work itself. So based on all that, and even if in this case, Your Honor decided that to require disclosure of the information here, the information that being the financial, I guess, underpinnings of what the actual work of the property has done, it's clearly something that falls within trade secret. My clients keeps closely held and does not disclose what the costs are, their internal costs for producing and creating a roofing system. And to be perfectly honest with you, anything as far as bids or anything else goes, clearly would move into the realm of trade secret, in that if their competitors found out what their bid amounts were, what their profit margins were, other competitors could outcompete and outbid my client, Castilla Roofing, in the marketplace. So if Your Honor was even able to or decided to require disclosure of any of this documentation that goes beyond what we've already put out, we ask that it would be done under a confidentiality order requiring that none of this documentation be disclosed beyond this case itself or used in any way.
Okay, respond. I guess we'll hear argument from the defendant, because it's the defendant's subpoena, correct?
Certainly, Your Honor. Just a few things, obviously just going through. With respect to the date of the subpoena, obviously, we don't have control over when it's served. If there's an issue, if for some reason the subpoena was delayed in service and there's an extension that's needed, both mine and my assistant's emails are on the document. All that needed to be done was simply an email saying, we just got served with this document. Clearly, we don't have enough time. We need an extension, and clearly that would be granted considering the short notice of a subpoena. So that's really not an argument that's not, at issue here. Let's see, just looking at the document, the arguments, with respect to the claim that it's not reasonably calculated, that's not an argument that is appropriate for this stage of litigation. I know Your Honor's heard this many times, but relevance is an issue to be determined by the court when evidence is sought to be admitted. That's under the federal and the Florida statute rules for evidence, 401 and 402. The whole point of discovery is to obtain information that's reasonably calculated. With the utmost of respect, but counsel's opinion that it's not reasonably calculated doesn't meet that standard. When we obtain all discovery, we present it to the court for admissibility. That's when its actual admissibility is determined, not now. Also, respectfully, I don't think that it's accurate for counsel to state that somehow the cost of replacing the roof of this property is in any way not reasonably calculated to lead to the discovery of admissible evidence in a case that is regarding the cost to replace the roof. With respect to some of the other arguments that counsel made, he asked why it would be relevant information. I think that's a pretty simple argument. The roof has actually been replaced. As Your Honor can see from our subpoena, we are asking about information with respect to this property and the damages in this claim. The roof has been replaced by Castilla. Clearly that is relevant as to the amounts that are being sought. In this case, there is an estimate for over $300,000. Clearly it is relevant for us to find out if the roof actually costs that much. Because if it didn't, and my client tenders that money, clearly that's an overpayment and that's not appropriate. Damages are fixed. The work's been done. So we are absolutely entitled to find out, well, how much did the roof actually cost? With respect to the McDonald's scenario, again, respectfully, that's completely inapplicable. I think what happens is sometimes people forget that this is an insurance policy case. The policy dictates. We are not walking into McDonald's. Someone's walking into our policy and saying, pay me. And we're saying, okay, well, you have to look at the policy language and that will determine what is payable. So unfortunately, the McDonald's argument has absolutely no bearing on this. We're not asking them to do the work. They're asking us to pay for work under our policy. The policy is pretty clear. Replacement cost is the reasonable and customary cost, including labor and materials, to repair or replace the damaged property or any of its parts with material of like kind and quality. Obviously, the policy defines that. So they're coming into our policy and saying, we've done work, we want to get paid. The policy states, we only pay the reasonable and customary cost, including labor and materials, for the work that's actually done. So it is absolutely reasonable and relevant for us to know how much it's done, especially when the work has already been done. The price, the amount's fixed. Now, we can't help that the party here, SFR, pulled in a subcontractor to do the work. That's not on us. Unfortunately, that does bring in another third party, but that's on SFR. That's not on my client. The third party did the work. The subpoena is very narrowly tailored to this property and this claim. The other information that counsel put, and again, I'm trying to be very respectful here, but the allegations that somehow there's a certain approach that we're supposed to take to find this out, that's not correct. The damages are fixed. I don't need to go out and find an expert to give this economics lecture on market approach versus cost approach. The work is done. How much did it actually cost? That's all that needs to be determined in this case. The damages are fixed, and based on the language of the policy, we're entitled to know that amount. So the other information is sort of abstract. This is a concrete issue. Work is done. How much did it cost? And then respectfully, with respect to the claim of trade secret, unfortunately, this does not rise to claim to trade secret. Counsel's claiming that if somehow this information got out, well, this information wouldn't get out. As counsel already noted, and case law has noted, that can very easily be remedied by having some type of confidentiality agreement for the information. We don't have a problem with that. If that had been proposed to us, we certainly wouldn't have an issue with that. Obviously, when you're dealing with something that they're claiming is trade secret, I don't have a problem. I don't want everyone else to know. I just need to know the amounts for this case. I'm not looking for financial underpinnings. I'm looking for, what did you do in this case on this property? How much did it cost to replace this roof? I don't want to know anything else. I'm not interested in anything else. All I want to know is how much did it cost in this case to do this work, as very clear from the subpoena. The documents we received did not address any of that information. The only documents that I have are documents that, such as the notice of commencement. I received a permit information without actual information of what it cost. That's what we've received so far. But otherwise, those documents do not rise to trade secret. This is about this one incident that can easily be remedied. Any issues can easily be remedied by signing a confidentiality agreement that the information is only going to be used in this case. We're not asking for their overarching, how do you do this on every claim and, in the county and whatnot. We're talking about this claim, this roof, how much did it actually cost this company? How much did you charge and how much did you accept? based on the policy language under which the claim is brought, that is absolutely a valid reason for us to be able to get this information. And even under the case law, which, you know, we're allowed to get certain information if we can present to the court why we need it. It's very simple why we need it. They're claiming they did the work. They're claiming an estimate of $300,000. We need to know, did it actually cost you $300,000 to do the work now that it's done? Very simple. Unfortunately, SFR didn't do the work, so we have to go to the third party. We're more than happy to enter into some kind of proprietary confidentiality agreement to protect any information, and we have no intention of using it in any other case. We only need it to find out how much the damages in this case actually are. Just reserve a moment of rebuttal or answer any of the questions of the court.
Okay, thank you. Ms. Jimenez, did you have any position on this motion?
I don't, Your Honor. I deferred it to you, to Your Honor.
Okay. Mr. Falatek, did you have any rebuttal argument?
Yeah, to be honest, I'm not sure why counsel started out addressing relevance and admissibility when I didn't make an argument as to relevance or admissibility. My argument was on the standard that counsel eventually got to, which was it being reasonably calculated to lead to the discovery of admissible evidence. The fact of the matter is this, Your Honor, I posed in my portion of the argument that I haven't seen a single case where it says that the cost approach that's taken, or essentially taken by counsel and by Tower Hill in this case, is an appropriate valuation of what fair market value, that is, what the value is under a policy for replacement cost value, that is a proper approach. I still have never seen that in all the hearings that I've done, and I think it's because there's no case law out there that actually supports that conclusion. There certainly is case law that says that fair market value and replacement cost value are essentially the same thing. What we have here, and whether or not counsel wants to, I don't have a copy of the policy, so I can't read from it as counsel has. But I know one thing, and it's that the majority, and I believe Tower Hill's policies also talk about, there's a definition of what and who is being indemnified for. The insured is generally referred to as you. And the insured is generally referred to as the individual who's the name insured or those individuals who are related to and living at the property. That certainly doesn't cover a third party, an assignee. The fact of the matter is Tower Hill does not indemnify SFR or Castilla for the work that's being done. They indemnify the insured for what it would cost to have the roof redone. And that cost is what the cost would be to the insured. That is the fair market value. It is not what the cost would be out of pocket to the subcontractor or contractor. That is what they would charge. It just completely ignores the idea that, and to be perfectly clear, Your Honor, as I said in my original opening was, we only see these in AOB cases. We don't see it, and if what counsel was arguing was correct under interpretation of the policy, and the policy language as counsel put as the policy dictates, we would see this argument in quite literally every single case that there was out there where an insured, either whether or not they even did the work of the property, if they had signed up a contractor to do the work and the contractor said, well, here's my estimate for how much I think it should be cost, you'd say, well, I want to see how much you actually spend on nails. I want to see how much you actually spend on decking and everything else. That's simply not the case here. The proper way of assessing this under the policy is what the policy actually pays for. That is the cost to be insured for what the full roof replacement is, and that's based on what the fair market value is. And the proper way of approaching that is obtaining an expert to say, here's what the fair market value for this roofing system would be. Not to get into, well, what the out-of-pocket was to a subcontractor that, to be honest, and we're talking about 401 or the relevance and what may confuse and obscure the issues for a jury. Simply put, without case law or without any statement saying, hey, look, this cost approach is what really matters, not the fair market approach. We're looking at moving into evidence that's going to be presented to a jury. And again, I'm not getting to relevance or admissibility. I'm simply getting into if it's reasonably calculated to lead to discovery of admissible evidence. It's counsel's burden to say, well, here's how this is reasonably calculated to lead to discovery of admissible evidence. And that's going to be how it's actually going to relate to the issue, the damages issue, which I still haven't seen a single case or seen a single issue that says what their theory of the case is. It's what's actually applicable under the law.
Okay, I have a couple of questions. So, Mr. Falatek, as I understand the arguments or the factual posture of this case, SFR is standing in the shoes of the insureds in order to obtain benefits under the policy, and they have hired Castilla Roofing to make complete repairs to the property. Is that correct?
Yes, Your Honor.
Okay, so if the homeowner, let's say there was no assignment and it was just the insured homeowner hired Castilla Roofing to make the repairs, and Castilla made the repairs, are you telling me that the amount that the homeowners paid Castilla for the repairs would not be relevant?
If the homeowners paid it, they would be relevant because the homeowner is who's being indemnified by the policy. The homeowner's general contractor or which would be SFR, or the general contractor subcontractor, which is Castilla, is not relevant. That is their out of pocket, their costs. So I mean, what they're asking for here is Castilla to show what it is that Castilla would require from SFR to do the work of the property. That is what the subcontractor would require from the prime contractor. The subcontractor's bill, that is what went into it, and depending on how far down the rabbit hole an order may go, I mean, whether it's have to show receipts from Home Depot and ABC for, Home Depot for nails and decking, ABC for tiles, things like that. I mean, I don't know how far down the hole that they even keep records for, to be honest, on those issues. But the fact of the matter is, what the policy indemnifies for is fair market value that would be paid for by the insured, not what the actual cost out of pocket to produce something. It'd be the idea of if an insurance company insured a Ferrari and the Ferrari was valued at $300,000, I don't think a Ferrari actually cost $300,000 to produce. But it's still insured at $300,000, not whatever the amount it actually took to produce was.
So I think your argument, Mr. Falatek, is that you shouldn't have to show the underlying costs that go into the total price that was paid to repair the roof. I want you to show me where in request numbers 1 through 7 that information is requested.
Well, that's going to be the financial information that falls under, I believe, number 2, where it's talking about the materials, and number 1 specifically, which is broad enough that it's the entire file. That includes what the invoices were issued. How much it is that essentially Castilla Roofing would have charged to charge the prime contractor to do that work. And it's very simple here. What Castilla Roofing would charge a prime contractor is not necessarily what's reflective of what the fair market value of a roof would be. And that's simply because you have other factors that come into account, whether it's a relationship between the prime and the sub that has increased volume. Whether it's something where there's some sort of a agreement as to, and I'm not saying that's in the case, to be perfectly honest, I don't know if there's an agreement in this case as far as price per square or anything like that, which I honestly don't know, so I don't want to put that out there and say that there is. But if there's something of that nature that changes how a subcontractor may charge based on market conditions at the time, these are all factors that might come in that, to be honest, they don't actually influence what the actual cost of the property would be in the fair market.
Okay. Ms. Procco, are you actually seeking that information? Because that's not how I read request number 2, but I want to make sure that we are on the same page about what you're seeking.
No, I'm a little confused. I was kind of looking at the request. I was a little confused about counsel's statements. It doesn't say any of that. We're asking for proof of the actual work that was done, including payment for that work, what was done, any services provided, and how much did you get paid for it? That's all we're asking for. It's very limited to what was done on this property and how much did you get paid for it.
And the issue there is how much you got paid for it, because how much the subcontractor was paid for it is not necessarily reflective of what the fair market value was because of various factors we described.
I heard that argument. I'm familiar with it. Thank you, Mr. Falatek. So I'm looking at the affirmative defenses in this case, and I don't know if you're familiar with them, Mr. Falatek, since this isn't really your case. You're a non-party.
No, Your Honor.
But I'm familiar with these SFR cases, and I know a lot of them contain the material misrepresentation exclusion under the policy, or I guess it's not really exclusion, it voids the policy for if you make a material misrepresentation. So 6th affirmative defense alleges that SFR Services has made material misrepresentations as to the purported value of the repairs reflected in SFR Services estimate. Tower Hill is aware that SFR Services utilizes subcontractors to perform repairs, which subcontractors charge amounts far below the amounts contained in SFR Services estimates, including the estimate in the subject claim, et cetera, et cetera. So, I mean, the pleadings do include the assertion that the plaintiff has misrepresented the value, that they charge well in excess of what they pay the subcontractors. And while I note that fair market value is not the same as what it costs the subcontractor to do the work, the subcontractor's work is part of what goes into determining the fair market value and the reasonableness of that amount requested. So I have ruled in other cases in the past that what repairs were made and the cost of those repairs are reasonably calculated to lead to the discovery of admissible evidence, given the nature of the affirmative defenses that have been raised in these types of cases. That does not, in my mind, get to the minutia of what it costs Castilla to do the work. So I don't think this includes what Castilla paid for tiles and nails and what have you. And I mean, I don't know if it's the reference to the word material that leads you to believe that, Mr. Falatek, but the phrase documents, records, or materials is defined to be documents. It's essentially a very broad definition of the word document. So I don't see it as, you know, supplies or costs or things of that nature. So as I read request number 2, it is documents evidencing proof of repairs that were made, goods or services provided by or on behalf of Castilla for the benefit of the plaintiff and or the insured property. Now, I do want to be clear, it's the subject claim. I don't care if it's the owners for any other property or any other time, it's this claim. So I will narrow number 2. So it's for the benefit of the owners for this claim, and I guess it could be the owner or the property, but it should be narrowed to this claim to be clear. And then it goes on to say, including proof of payments for same for this time period, as well as, again, documents evidencing the identity of the persons who completed those repairs and or any goods or services, so who provided the repairs on behalf of Castilla for the benefit of the owner or the insured property. Again, that should be limited to this claim, to be clear. So as I understand that question, Mr. Falatek, do you still believe that number 2 at least invades trade secret information?
The price that my client would do a roofing system for is still something that my client believes is protected by trade secret.
The price that they charged
That is correct.
in an invoice that they provided to a third party. Now, I know your motion references a confidentiality agreement. Do I have that available for me to inspect in camera?
I don't believe we've submitted that. We can, Your Honor, if you desire. But it did not seem that counsel was disagreeing with the propriety of a confidentiality agreement between the parties during your argument. So,
well, so the analysis for trade secret is a 3-step analysis. The first step is it a trade secret? And that has to be normally determined by evidence and or an in-camera inspection, regardless of whether you agree to a confidentiality order. Unless the parties are agreeing to utilize a confidentiality order without the court making a finding as to whether it is trade secret, or if you are stipulating or consenting that it is a trade secret. So in the absence of a stipulation that this pricing information would constitute a trade secret, there would have to be an evidentiary finding in that regard. And then you get to reasonable necessity. Is there, the second step is there a reasonable necessity to get the information, even if it is a trade secret? And then the third step is if there is a reasonable necessity, then what are the protective measures? That could be a confidentiality order. So Ms. Crocco, are you conceding that the pricing information and I guess it would be in the invoice information or the payment information is a trade secret such that I don't need to have any evidence in that matter?
Your Honor, we don't believe that that is in any way trade secret. We were just agreeing to have a confidentiality agreement in order to be able to get the information and to facilitate this. But no, there's no evidence, particularly under the case law, that any of the claimed information is in any way trade secret.
All right, and Mr. Valtek, I assume you're not agreeing to those being produced without them conceding a trade secret status?
No, and I believe that the nature of the documents that we're discussing here, which are financial documents, which are under protection of a confidentiality agreement, are by their very nature something that would be considered trade secret. We're not going to be we're not withholding or anything back that wouldn't be under that confidentiality agreement and wouldn't have to do with financial record or financial documents or documents that go directly to finances. So while the case law does lay out the procedure there that you're talking about, it also talks about specifically what is and is not a trade secret. It's clear based on that. And we can give it to Your Honor for an in-camera inspection, but that's the long and short of the documents at issue. That's all it is.
Right. I mean, for it to be trade secret, it's not just that it's a trade secret, but also that there are reasonable protective measures in place to prevent that information from being publicly available or available to people who would obtain a financial benefit from having that information. So sometimes it's obvious from a review of the documents, but sometimes it's not. So I can do an in-camera inspection and do the best I can based upon just reviewing the documents. But if it's not clear, then an evidentiary hearing might still be necessary in order to provide the factual basis for these documents qualifying as a trade secret. But I think the best we're going to be able to, because that's going to be, I don't think we can do that today because I don't have the documents here. But I think what we can do today is narrow the scope appropriately so that we know what the scope is. Then Mr. Falatek would, or his client would have to gather the responsive documents, figure out what is trade secret or what is not. And if it is trade secret, it would be segregated for purposes of the court doing an in-camera inspection. And anything that's not trade secret but is otherwise relevant would be produced. I'm not aware of any other privilege asserted other than trade secret. Is that right, Mr. Falatek?
No, Your Honor, not that I'm aware of.
Okay, so let's finish up with scope. So number 2, I'm narrowing to the subject claim. Now I know some of these other ones already limited to the subject claim. What are there other specific requests 1 through 7 that you take issue with, Mr. Falatek, other than number 2, which you specifically raised?
And just bear with me one moment, I'm just reviewing.
Sure. I mean, it seems to me like documents exchanged with the building department would not be confidential trade secret information.
No, and I believe we've produced those to counsel already as part of a prior production. So I don't even think that's an issue. As I said, I know we produced photographs, and I believe I'm looking through the file here of what we've actually produced already, and I can see that there are documentations from Lee County. I think counsel conceded we produced the COC. While I don't have any problem producing that, I'll note that any of the documents that are with Lee County is something that's easily searchable by counsel and counsel's office on the Lee County website for permits and whatnot. But I don't think that's an issue.
Well, what may be publicly available is not necessarily all the documents that were exchanged. So I just, I normally don't.
Yes, Your Honor.
Sustain
I understand.
Because they don't know what else may have been exchanged, which is not publicly available.
And I don't believe we withheld anything of that nature anyway. So that's not it. I can see that whatever documents that we may have withheld, and they're quite literally just go to costs. That's it.
Okay, so are there any other specific requests? So I think that the finding that I've already made to limit it to the subject claim would also apply equally to, for example, number 3. 4, and 7. And actually number 1 is not limited to the subject claim. I think all of those need to be limited to the subject claim. So other than that, are there any other specific scope issues you want me to address today, Mr. Falatek, that you asserted in your motion?
No, Your Honor.
All right, so what did I say? 1, 3, 4, and 7? Yes. All right, so that's the scope. I'm gonna say we can set a time period within which documents need to be provided unless you're withholding them based upon trade secret, in which case you will provide those documents to me for in-camera inspection. I can't make you do a privilege audit because you're a non-party, but you can segregate them and identify them as being withheld based upon that. I would need not only the documents, but also this confidentiality agreement that you've referenced in your motion in order to review that. And then how much time would you need from an order adopting my report to do that, Mr. Falatek?
I'd say 20 days.
Okay, so 20 days from the order adopting to produce what's not asserted to be trade secret, and then to defendant's counsel, and then or to produce to me for in-camera inspection anything that you do assert to be trade secret or contain trade secrets, along with any other, the confidentiality agreement or any other material that you think supports the finding of trade secret status for that information. I also wanted to clarify, because your wherefore paragraph in your motion talks about canceling a deposition. I don't think there's a deposition at issue in this case, and you're just talking about a subpoena, but I want to be sure.
Yeah, I believe that was included in there.
Okay. All right. Well, so is there? So I narrowed number 2. Well, let's see, 1, 2, 3, 4, and 7 to the subject claim. I also clarified on number 2 that it does not include Castilla's underlying pricing, that it only includes what Castilla charged and what was paid. Anything else that you want me to address regarding scope while we're on the record today, Ms. Krakow?
No, I don't think that's it. I don't think there's anything else, Your Honor. Obviously, we just ask all documents. I will point out with respect to the documents that were produced with respect to the building department. I know we didn't get a copy of the permit application, so that would be something I don't believe we can get online, so we would certainly need that as well.
If we have it, we'll provide it. I don't know if it's something we have, but.
Okay, and then Ms. Jimenez, was there anything you wanted me to address or clarify?
No, Your Honor, not from my end.
So just to kind of go through the procedural process, if there are documents being withheld for trade secret, those are going to be produced to me for in-camera inspection. I will review them. I would do a separate report from today's. So there's going to be one report from today's hearing, setting forth this 20 days to produce or either to defense counsel or to me for in-camera inspection. If I receive those documents at some point in time, then I would do the in-camera inspection, do a separate report and recommendation. I would not order the production until after the entry of an order adopting my report on the in-camera inspection. If I were to find that there needs to be a hearing, the report would recommend that a hearing be set, an evidentiary hearing be set. Just trying to go through, I would ask that Mr. Falatek retain the original documents in case the court were to ever need to like the judge were to ever need to review them for purposes of an exception. So I usually would return them to whoever provided them to me so that they get them back, because I don't want to be responsible for having them. And then Mr. Falatek, when you provide them to my office for review, please copy counsel on the letter enclosing them and producing them to my office so that counsel is aware when it was provided to my office. Obviously, you would not include the enclosures so that I'm the only one actually receiving the enclosures, but everybody knows the timeline and when it was provided to me, okay?
Yes, Your Honor.
Are there any questions or clarifications on anything, the procedural matters or any other matters while we're on the record, Mr. Falatek?
Just who do you want writing the report and recommendation?
Well, it is your motion, so I'm going to ask
do that.
Mr. Falatek. I would appreciate that. I do reserve the right to make changes to it, but I like to know whether you all can agree on the form, or if you can't agree, what your specific disputes are, so that I can do my very best to try to address those issues in the report. Do you want to preserve the exception period, Mr. Falatek?
Yes, I'm going to preserve out of abundance of caution.
That's fine. Do you all have any immediate deadlines coming up, Ms. Crocco, that I need to be aware of, like trial dates or anything like that?
Do not believe we have a trial date. If it is, it's not anytime soon. So I think we're okay for a little while.
Because we're talking about the report from today, 20 days from the order adopting to produce them, then the in-camera inspection. So it would be, a couple months by the time this would finally be resolved if there are documents produced to me for in-camera inspection.
Understood.
Okay, so Mr. Falatek, I know you're familiar with my process and my template, so I won't repeat it on the record unless you have any questions.
No, Your Honor, we'll use the new one.
Okay.
Newer one.
Newer one, yeah, it's December.
Yeah, it's been about 5 months now, so I guess it's not new anymore.
Time flies, man.
Yeah.
That'll be all for today. I hope you all take care. You're welcome to leave the meeting. Thank you very much.
Thank you.
you,
And Madam Court Reporter, we're going to order, please.
Thank you.
Okay, thank you so much. Have a great afternoon.
Take care, you too.
And Your Honor, do you have something between now and 2:15? I think I'm in front of you again on 2:15.
I do not. So if you want to, I'm going to go back to my office, but I will leave this running if you just want to.
Yeah, I'll just put myself on mute and hang out.
Okay, no problem.
And I'm here with you again at 2:15.
Okay, well, everybody can turn off their video and hang out. I'm going to go back to my office.
Thank you.
Thank you.
Great, thanks. there she is. Okay. Go ahead and let everyone in. Good afternoon. We still have one person connecting to audio. If you could please bear with us. All right. Good afternoon, everyone. This is Magistrate Bocelli. I've let in everyone who was in the waiting room. I believe we're all here for 20 CA 8465. Oh, somebody else just popped up in the waiting room. Let me let them in as well and let them connect. If anybody's not here for the 215 and you're just early for a later hearing, let me know. All right. So we're here for 20 CA 8465 SFR Services LLC versus United Property and Casualty Insurance Company. I wanted to note that this is being live streamed to YouTube in order to maintain public access to the court. So please keep that in mind. I believe we have Sharon Roush of Ryan reporting as our court reporter today, and she will have the official record of our proceeding. I'd like to get appearances from counsel, starting with plaintiff.
Joseph Bendel is here for the plaintiff, Your Honor.
Thank you. And for the defense? You have to unmute yourself if you're speaking because I can't hear you. Still can't hear you.
There we go. Sorry, Your Honor.
Okay.
Working from the office today, and so I'm instead of working from home, and so everything's a little new and different. Attorney Mark Stewart on behalf of UPC.
Thank you very much. And for the non-party move-ins?
Yes, good afternoon, Your Honor. Justin Falatek on behalf of non-party First Services CGC, Inc.
Very much. And I do see one more person. We have Robert Shelton. Are you here for the 215, sir?
Good morning, Your Honor. Yes, I was. I'll be here. I'm just shadowing Mr. Stewart for the hearing.
So you're with Mr. Stewart's office?
Yes, Your Honor. Chartwell Law.
All right.
For the defense.
Okay, thank you. All right, so we're here on the non-parties motion for protective order filed March 24th, 2021. The order of referral was April 28th, 2021. I'll turn it over to Mr. Falatek for argument.
Yes, Your Honor. We're here on a objection to a non-party subpoena that was issued by defendant United Property Casualty Insurance Company. This one is a subpoena ducis tecum with deposition. I'm going to address the deposition portion of the subpoena first because I think that's the easiest one for Your Honor to rule on, and then we'll address the document request second because that's going to, at least on my end, going to involve a little bit more record laying based on Your Honor's prior ruling. The subpoena was issued, well, I should say, was served on March 4th, 2021, noticing a deposition to occur on March 19th, 2021. So as a initial matter, I'd argue that the subpoena filed or served 15 days prior to the actual deposition date itself is untimely, and that it doesn't provide the non-party sufficient time to respond to and produce documents in response to the subpoena. The bigger issue with the subpoena is the subpoena is written, it's directed to First Service CGC, Inc. That is a corporate entity. The subpoena itself is noted as being under, or I should go back. I don't believe the subpoena actually states the rule that it's being issued under the notice of production from non-party. Notes that it's under Rule 1.310 and 1.351. Assumedly, since this is being produced on or served on First Service CGC, this is a 1.310B6 subpoena under the corporate representative depositions rule. The first and most glaring issue is the subpoena itself doesn't have any areas of inquiry. So as far as for a deposition goes, the subpoena, at least, and if somebody can point to something where I'm missing it, the one that we received is insufficient on its face, and that it doesn't provide areas of inquiry under a B6 designation. Shifting to the documents being produced, we're objecting to production of documents And based on the scope of the documents being requested, or going to areas that are not reasonably calculated to lead to the discovery of admissible evidence. And the long and short of it is they're seeking documents which would go to one of two things, and both being financially geared. One would be the amount at which First Service was paid for the work that they did at the property. The second would be, and again, I'm not sure how far down the rabbit hole the request for production portion of the Duces Tecum is seeking. But the way that it's presented, it seems as if they would be looking for documents regarding what was paid in assessing or in obtaining the materials in order to create or to complete the work at the property, whether that was what First Service essentially went out of pocket to go out and buy from Home Depot, ABC, or some other area. We object to both on the basis that, number one, it's not reasonably calculated to lead to the discovery of admissible evidence, as the standard under a policy of an insurance is essentially what a homeowner would pay a contractor to do the work of the property. That is, in other words, the replacement cost value, which is interchangeably used with the fair market value. That is what the market prices would dictate, not necessarily what a subcontractor or even a contractor would pay for work to be done. Their requests regarding proposals and other items there, including invoices and receipts, would show quite clearly the financial information and backing of my client, which would go to being documents and items that are protected by trade practice. And to be clear here, I want to just make a distinction. The interaction of what may be paid between a contractor and non-contractor, that is one type of confidentiality that's between in the interaction themselves, but there's completely separate of what the client would have First Service CGC and how they handle their financials and their inner workings too. So I don't want to conflate the two issues, and I think Your Honor in your previously ruling has kept those two apart. I just want to make sure that's clear on the record. So for essentially what we're objecting to here is any document production that would go to cost associated, whether it's what the First Service has received or what First Service actually paid in order to complete any work at the property. Simply with the fact that that work is not, and again, I'll go back on the record and say, I've never, basically the insurance defense bar in the last, 6 months now has been adopting this position that the cost approach of what a subcontractor or what a contractor pays is indicative of what the fair market value or what the value is owed under an insurance policy of insurance. To this day, I still haven't seen a case that actually says that, and anything that's actually persuasive in nature. There is case law out there that says that fair market value and replacement cost value are essentially interchangeable, and I believe that's the approach that is should be adopted and taken forward. Until that's shown that there's some other approach that's valid, essentially it's a red herring and seeking document production that's not reasonably calculated to lead to the discovery of admissible evidence. That's it, Your Honor.
All right, before I get a response, I just have a couple clarifying questions to make sure I'm looking at the right notice. The motion references an Exhibit A, but I don't see one being attached, and I don't see a notice of deposition. The closest I find is on February 19th. There's a notice of intent to serve a subpoena, to serve non-party subpoenas, and that's First Service. So I think that's the one we're talking about, but I want to make sure. Is that the right one, Mr. Palatek?
The one I'm looking at was the March, there was a March 4th, 2021 subpoena that was issued.
Well, I think that's the service date, not the filing date, and I don't have a copy of it. So that's what I'm trying to find is either the subpoena that was actually served or the proposed subpoena that was intended to be served, because there's nothing filed on March 4th.
Okay. I wasn't aware of that. I can share my screen for you so you can at least see it, Your Honor, if you'd like me to do that.
Now I'll have to allow that for you. So hold on just a moment.
And in fact, do we have chat? Here's what I can do. This will be even easier for you.
So the one I found is a notice of intent to serve non-party subpoenas with an S, but then there's, I think the only thing attached to it is the subpoena ducis tecum with deposition to First Service CGC Inc.
Correct, Your Honor. And I'm sharing it. I tried to drop it into the chat panel so you could open it, but it didn't let me.
Okay, I think that's the one filed on February 19th.
But that would sound.
Okay. Does counsel for the defendant, can you confirm that?
Yes, Your Honor. And if you look at the subpoena, it's not highlighted as well as I would like, but in the middle of page 2, it says that you may comply with the subpoena by providing legible copies of the items on or before the scheduled date of production. We're only seeking at this time document production.
Okay, well then your subpoena is supposed to, it's not supposed to say with deposition. There's a different procedure if you're wanting to do it without a deposition or if you're wanting to do it with a deposition, and it's not clear from the title of your document. Because if I read that, I wouldn't think that the objection period were to apply, because it's not indicated that it's a document only non-deposition subpoena. Because that's my question. There was no objection filed by anybody, but it's not clear that that's what you were trying to do.
I apologize for not using the best method. We were just attempting to subpoena the documents that are set out in the First Services CGC subpoena.
Okay, so before we go back, Mr. Faltek, does that change your argument at all to the extent that they're essentially clarifying that they were not intending to set a deposition, that they were just trying to get documents?
Well, that makes the 1.310B6 argument kind of unnecessary. So we can just address the document portion.
Essentially just addressing the objection to the documents. Okay,
Yes,
so
Your Honor.
I'll hear a response then from, I assume, Mr. Stewart.
Yes, Your Honor. As far as any issues about time, I would just point out respectfully that the motion that's filed says that there wasn't sufficient time to produce documents. However, we've not moved to compel. We've not taken any steps to sanction or otherwise hold them to a particular time. We're just trying to get the documents. And in fact, I would say that most of their arguments are actually waived by the fact that they didn't recently produce 215 pages of production. Now, of that production, it includes building permit documents. It includes a large number of photos. It includes 1 or 2 homeowners association documents, but it includes no invoices, no contracts, no billing information, which comes down to the question of trade secret. Now, reviewing the case law that's cited in the motion, the case law cited in the motion cites a case called, let me get the correct name, Gulf Coast Surgery Center, Inc. versus Fisher. Now, as far as I can tell, that is good law, although there is subsequent law that fleshes it out and expounds on it some more. That particular case says that the question of trade secret depends on whether or not, let me get the right line, whether or not you're giving up the methodologies as to how a cost is determined. Later cases explain in more detail what is or is not trade secret, and I would ask Your Honor to take a look at the case of Lake Worth Surgical Center that, based on the prior case, it states that internal cost structure information, including methodologies or formulas that are used to compute pricing and reimbursement rates, those constitute trade secrets. However, where you have just the price for a single transaction, that does not constitute trade secret. So in other words, if you're looking for information about how First CGC determines its pricing, how it determines what its costs are, that would be a trade secret. what it charged for this particular job to do the work that it did on behalf of SFR services and any monies that it paid or received, that would not be trade secret because that's just what was paid on this particular job or what was built into this particular job. So the documents that we're looking for, and if you look at the subpoena, it's all very clear that we're, and very specifically set out that we're looking for information regarding work done at this particular address within a 4-year scope of time, January 2017 through January of 2021, and specifically regarding DACA Investments, who at the time was the homeowner, and Harry Young and Shirley Young, who were the named insureds and were also managing members of the corporation DACA Investments. It just happens they own the property through that corporation. So we've carefully tailored this subpoena to be just work regarding just this job. So nothing that we've asked for should qualify as trade secret. And moreover, to touch the argument that counsel made as far as what is the right way to value this job, well, that's an issue of determining what the policy says, which is outside the scope of this particular hearing. But I'm going to touch on it a little bit anyways, because we are required to show that what we're seeking is discovery that's reasonably calculated to lead to the discovery of admissible evidence. What we're seeking for is admissible, and it's certainly relevant, because when you look at the photographs that they provided, they show certain pictures of the roof, and it has underlay that says polyglass polystick TU Max. Now, I don't know if your honor's familiar with this or not, but in roof underlay, that means this is what's called a synthetic polyglass underlay. Now, when I look at the estimate that's previously been provided by counsel for Elite Claim Service, their estimates include $17,000 to remove and replace modified bitumen roof for $17,000, which is a different kind of roofing. So I have a particular area of concern where their estimate says one kind of roofing, their photographs show that a different kind was put on, and they're trying to keep us from having access to the actual cost of what the building was. So one, we're entitled to this because it's admissible evidence, and it's our request for the subpoenas reasonably calculated to lead to admissible evidence. Their estimate they're seeking is for one thing, but they built with something else. And as I talked at some length, where we're limiting this to one particular transaction with one group of individuals at one address, that's not trade secret. That's a particular individual transaction, and so it's not covered under trade secret. So we are entitled to everything we've asked for, Your Honor.
Okay, just to confirm from plaintiff's counsel, do you take any position on the motion?
No position, Your Honor.
All right, thank you. Mr. Fowler, take any rebuttal?
Yeah, I mean, to start off and address directly, I didn't plan on getting into an argument here as to whether or not polystick is or is not considered modified bitumen, but I'm just going to share a screen with Your Honor. This is a letter that was sent by Polyglass USA Inc. to one of my clients, talking about specifically in here where it says, these polystick underlayments are manufactured using polymer modified bitumen asphalt compound and are considered modified bitumen products by definition. So the argument that Mr. Stewart just made is factually incorrect on its face. I don't know why he would say that, but he did. Putting that aside, I want to address the case law portion that was argued. I'm not going to sit here and argue over and what the proper procedure is or isn't for addressing a trade secret claim. I would love to see the case law that Mr. Stewart is citing that says that a single instance is not something that is covered under a trade secret, because to be perfectly honest with you, I don't think that there's case law out there that specifically says one instance cannot be a trade secret. I believe that's probably in direct conflict for what the case law says. Either way, what we have here is evidence of financial records, whether it's one instance or 10 instances or many instances, which are underpinned by a effort of confidentiality to keep them from being known by the general public. And if they were known by the general public, specifically First Service's competitors, First Service could be underbid and outcompeted in the marketplace. That is, whether it's one instance or 10 instances or 100 instances, it is a trade secret. And it makes no sense logically, because if Mr. Stewart filed this very same motion in 10, 15, 30 cases, at what point does that become a situation where it's now addressing a trade secret rather than an individualized issue? Putting that aside, even if Your Honor was to order production of this documentation, which First Service still feels is not reasonably calculated to lead to discovery of admissible evidence, I'll go back to what counsel argued. Counsel said it details what the policy says, and but that's outside of the scope of this hearing. With all respect to counsel, this is what he's requesting. These are the documents he wants. I don't understand how he can say, well, this is what we want, but this is outside of the scope of the hearing and it's admissible and relevant, which are all just conclusory statements on their face without anything underlying it. But one thing he provided, which is that, oh, well, it has a line item in there with a picture of polystick versus mod bit. That's not even true. So what we have here is an insurance carrier that is, I'm going to call it how it is. We have multiple insurance carriers that have decided that SFR Services, for whatever reason, does too much work, does too many lawsuits, and they've decided to go after and harass SFR Services subcontractors. That's what this is. They want to get into the money. They want to be able to disclose this so they can file things like RICO suits and other things that have absolutely no basis. And that's where we're here today. This is something that's simply designed to go after and harass First Service. And, you know, in making that statement, well, we'll go ahead and we'll just throw out statements about roofing, mod bit, and what is and isn't, and hopefully the court will just address it. And to be honest with you, the fact of the matter is they have the standing to sit there, or they have the position. They need to say why this evidence is necessary, why this is something that's even should be required to be even addressed in the first place. Otherwise, they just keep dragging in First Service and other roofing contractors here to defend themselves on issues that, quite honestly, they have nothing to do with. I still haven't heard Mr. Stewart or anyone else say why it is that a cost approach is the proper way of assessing what damages are under an insurance policy. And I don't know why nobody can do it, and the only reason I can say why they can't do it is because it simply isn't.
Okay.
All right, Your Honor, to respond to a couple of those things, the policy says my client is required to pay the actual cash value of repairs. Now, that would be one contractor doing the roof, not a contractor hiring a subcontractor, his own markup on top of that. So this goes to what the cost of the value is. I don't know where this RICO claim is coming from, because no, that's not what we're doing. I don't know where that's coming from. I'm trying to establish the actual cost of repairing this roof. As regarding the case law, I would like to provide citation to the case that I'm reading, and it recites back to the case that is cited by counsel. The case that I'm citing to is Lake Worth Surgical Center versus Gates, 266 Southern 3rd 198, and that's 4th DCA 2019. And it does cite back to the case law that they cite. It just builds and expounds upon it. And it says that one individual interaction is not trade secret. So it's just where you have looking for a methodology or a formula or their system of billing. So thank you, Your Honor.
I'm going to repeat that back to make sure I wrote it down correctly. 266 Southern 3rd 198.
Yes, Your Honor, that's correct.
All right. Well, I haven't read it yet, so I guess I'm going to have to read it to the extent that it's relevant to my decision today. Mr. Stewart, I understand your argument is that it's a reasonableness of the damage, essentially, or the reasonableness of the cost of repair. Did you have any affirmative defense, or does the defendant have any additional affirmative defenses that pertain to this matter? I know in other SFR cases there are affirmative defenses about voiding the policy for fraud or things of that nature, misrepresentation, I think. Do you have anything like that alleged in this case?
As far as unreasonableness of costs and excess costs, I'm sorry, I did not review the affirmative defenses in preparation for today. I'll have to look at them real quick.
Okay, take a minute to do that.
Yeah. Sorry, still getting over a cold here.
Yeah, I'm getting over something myself, so no worries. While he's looking at
Okay,
that,
second affirmative defense. I'm sorry. Second affirmative defense is that the. Let me scroll down and just read it verbatim. As for its second affirmative defense, defendant asserts that the amount claimed by the plaintiff for repairs and damages are exaggerated, unnecessary, unreasonable, and unrelated to the loss sued upon. The plaintiff relies on an overpriced estimate. That estimate the damage. Can you all hear me still?
Yes.
Sorry, phone just gave me an error there. Plaintiff relies on an overpriced estimate, and that estimated damage for areas of the property that defendants investigated reveal did not suffer physical loss. As such, plaintiff's estimate is excessive in scope and pricing. Therefore, any of the plaintiff's estimate damages that did not sustain covered physical loss are not covered by the policy. So we're saying overbreadth and excessive pricing and exaggerated.
all right, Mr. Faltick, any argument on the relevance in light of that affirmative defense?
Still going back to the framing of the damages under the policy itself, to be clear again, counsel argued that the ACV of repairs, what they're awarded, what they're required to pay. It's the AC of repairs as paid by the insured, not by the contractor. Again, I just rely on that argument.
Okay. I thought I had a question for you as well, and I lost my train of thought. Oh, there was a reference to the production of 200 and something pages of documents. Are there any can you identify specific requests that you take issue with, since it seems like you have produced documents in response to some of these?
We produced documents that were had to do with the permit applications, photographs, and bear with me 1 minute. I reviewed these earlier and I have them open here on my desktop. I believe that there was, the vast majority of it was photographs that were taken. It was the subpoena is taken, the notice of commencement, the permit, an Eagle View report, a home inspection checklist from SFR's inspection. I believe the property that was passed on to First Service, and that lets First Service know the scope of the work to be done. A Master Association Architectural Review Committee request for modification, and I believe somewhere just under 200 photographs. I will specifically object to the argument that Mr. Stewart made that we waived anything by producing these. With all respect, they didn't file their notice properly. What we did was proper. We produced the documents that we didn't object to, and objected to the ones we should have. If they had done the process, I kind of think as we should have, anticipating a deposition. So the only remaining documents we have left over, I believe, again, are documents that have to do with actual internal costs, what was paid, pricing information.
Okay, and I think you also made a reference to confidentiality measures. Is there an actual confidentiality agreement that governs the relationship between your client and the plaintiffs here?
I believe there is. Even if there isn't a written agreement, it goes to whether or not this would be something. I believe there is a confidentiality written agreement between the parties, but it's a 6 one way, half dozen the other argument of just because a written agreement wouldn't be in place, it doesn't mean that documents and relationships aren't kept confidential. But my understanding is that there is a confidentiality agreement between these two legal entities.
Okay, I mean, the reason I ask is because, as you said, the existence of a confidentiality agreement is not required, but it is relevant to the court's determination of trade secret status, because part of the determination of whether something is a trade secret is whether there are reasonable protective measures in place to prevent that information from being disclosed to people who would have benefit from it. Without having the statute in front of me, I'm just paraphrasing.
Yeah, sure.
Mr. Faltag and I had a hearing, I don't know, 30, 40 minutes ago in another case that had similar issues. I think he had made a reference before to my prior ruling. So I just want to be clear that we're not talking about these things outside of court cases. It was just another court case that we were talking about that had very similar arguments. So I do have one more question for you, Mr. Faltag. I think you've said your objections or the documents that are objectionable or that you want to withhold are really responsive, I think, to 1, 2, and 3 of the specific document requests. Is it fair to say that you're not really taking issue with 4, 5, and 6?
Yeah, I mean, 4 would only be as to correspondence that would be between the subcontractor and the prime contractor, which would evidence any pricing. 5, there's nothing. I believe we turned it raw photographs. 6, just the only objection to that would be to where it's a catch-all for everything, because it's any other document. So I don't know what that exactly means, but I mean, the primary is 1, 2, 3, and then slightly 4.
Okay. And do you need an opportunity to respond to the case that was cited by Mr. Stewart today?
I've initially reviewed the case here. The case does say single instance, but I don't believe that it goes quite as wide as what Mr. Stewart's trying to argue. And if you have one instance, that means all discovery, that essentially Florida trade secret law just no longer applies if you're looking to the price of one sale. Yeah, I'd like to respond or have the opportunity to review and get something to the court.
Okay, how much time would you need to do that?
Just bear with me 1 minute, Your Honor.
If I may, Your Honor, to the extent that they're asserting trade secret or privilege, I would not oppose this court entering orders saying that these documents shall not be shared with non-parties, and that would eliminate their trade secret and confidentiality issues.
Yeah, as long as it's non-parties and it's not being used by PTI, I'm sorry, not PTI, UPC, for anything outside of this litigation, then that's fine.
Okay, so let's back up. So as I understand these issues, if the parties agree to the disclosure of the information subject to a confidentiality order without the court making an express finding regarding trade secret, y'all can agree to that. But in the absence of an agreement, I actually would have to decide whether it's a trade secret or not. So Mr. Falatek, you are agreeable to the production of the information without a finding of trade secret?
Well, no, there would need to be a finding of, if Your Honor requires production of the documents, then we would agree that let me step back. My understanding of what Mr. Stewart just said, that if Your Honor that he would essentially, if Your Honor is going to require production, that he would agree to it being done under confidentiality agreement, which I'm fine with. I'm not conceding that Your Honor should grant production, but if Your Honor does, obviously, I would work with Mr. Stewart and the defendant to try and get a confidentiality agreement in place to avoid unnecessary cost to both other sides, arguing over whether or not they're actually trade secret.
Mr. Stewart.
Your Honor, I was volunteering one or the other to try and make it quick. I would not like to get into a situation where Your Honor determines that this is not trade secret, but then we have to go forth and negotiate a confidentiality agreement after the fact and drag this process out longer. I would ask that it be one or the other.
Okay, my follow-up question to you, Mr. Stewart, was whether you are willing to concede that the pricing information is trade secret such that I don't need to make that determination in agreeing to the entry of the confidentiality order. In the absence of an agreement that it is trade secret, or an agreement that the documents may be produced without a finding regarding trade secret status, the court has to make all 3 findings for purposes of trade secret status.
I'm not sure I entirely understand Your Honor's explanation, but if
I'll explain it if it would help you in answering my question. So trade secret privilege has a 3-step process. The first step is the item a trade secret? The second step is, if it is a trade secret, is there a reasonable necessity? Has the other party shown reasonable necessity for getting the information even though it is a trade secret? And then the third step is what protective measures should be put in place to ensure that the information is not, disclosed unnecessarily to protect the trade secret status of the information. So the court has to do all three steps in that order unless the party seeking the information concedes that it's a trade secret, or the party who would be producing the information is agreeable to producing it subject to confidentiality without an express finding of trade secret status. In either event, if it's a trade secret or you're assuming it's trade secret for purposes of the motion, a confidentiality order will most likely be required because it is being considered a trade secret.
Yeah, I don't know that we don't necessarily get to the same place at the end of this one way or the other. I mean, honestly, based on Your Honor's previous ruling, we probably do. So,
well, they don't have the benefit of my previous ruling because they weren't present.
I'm sorry. Yeah, so I'm sorry, Your Honor.
That's not helpful for purposes of argument. I think you've already indicated you are not willing to have them produced without a finding of trade secret status, which is why I then asked Mr. Stewart whether he was agreeable to the court finding trade secret status subject to the production of a confidentiality order for purposes of the motion.
Right. And to be clear here, our argument under the motion is to that second prong, that is, it says it being reasonably necessary to the case based on the arguments we made here. And it seems to be that Your Honor, in tipping your hand, is probably going to rule against us on that issue, which kind of gets us to the next part of whether or not a confidentiality agreement is something that's necessary. So if we're able to agree here today, Mr. Stewart, we may be able to cut out the process of wasting time and money submitting documents for an in-camera inspection. That's only going to delay production to your client.
I am not pressuring anybody to concede anything. I'm trying to narrow the issues as much as possible. So Mr. Stewart, would you like to concede trade secret status as to pricing information or not?
Not at this time, Your Honor.
Okay. In the absence of an agreement, then the court will have to make that decision. All right, so I believe that normally an in-camera inspection is required in order to determine whether something qualifies as trade secret status. Now, I have not read this case yet, and I have not received Mr. Falatek's response. So I can't make a decision in a vacuum. So I don't know what these documents are. I would most likely order Mr. Falatek's client to, within some deadline, either produce any documents that are not subject to trade secret or asserted trade secret privilege, or produce to my office for in-camera inspection any documents that are asserted to be trade secret so that I can do an in-camera inspection and determine whether they are or are not. I would also have to, as that part of that process, determine the reasonable necessity and the protective measures that would have to be put in place. I am limiting my scope to 1 through 4 of the subpoena, because those were and then number 4 is really only the correspondence related to pricing. Mr. Falatek, you've produced other correspondence that does not relate to pricing, is that correct?
To the extent that I would consider the applications to the county for the permitting being correspondence, yeah, that's pretty much.
Okay, and then as to number 6, it does appear to be a catch-all. I don't think it really adds anything to what's already requested in 1 through 3. So I would probably be inclined just to disregard it for purposes of I guess. All right, Mr. Stewart, are you pursuing number 6 beyond, to the extent that it might include things beyond what's already in 1 through 3?
I'm not aware of anything that I can point to outside of what's set out in 1 through 3 if it's given a reasonable interpretation.
Okay, so I'm just going to disregard number 6 and just focus on 1 through 3, and then the part of 4 that deals with pricing, the correspondence related to pricing. Mr. Falatek, can you do 20 days from the order adopting to produce the documents to me for in-camera inspection that you assert a trade secret?
Yeah.
Okay, so, and then I will also consider the legal authority that's been referenced by Mr. Stewart today. Any additional legal authority Mr. Falatek wants to submit. I will do a separate report recommendation that sets forth my findings if I receive in-camera documents to review in camera, so there'll be a report from today, which I'm going to ask Mr. Falatek to prepare, and then there's going to be a separate report regarding the in-camera inspection when I'm provided documents. When they're provided to me, all counsel should be copied on the correspondence showing that it's being delivered to my office so that they know what day it was provided. Of course, the enclosures would only come to me. The enclosures would not go to opposing counsel. I will return whatever documents to Mr. Falatek after my in-camera inspection is done. I will issue that second report. The documents would not have to be produced until, if I were to find that they should be produced, it would not be until after the court's entered an order adopting, and it would have most likely confidentiality protections in it to limit the use to this litigation. Any questions or clarifications while we're on the record today, starting with Mr. Falatek, since it's your motion?
Yes, just one question. Obviously, if I'm going to supplement regarding that case that Mr. Stewart cited, that could potentially change the court's ruling one way or the other. How would you like me to handle number one in terms? I think you laid out the procedure of, well, I'll put in a proposed report and recommendation. You'll change it. How would you like me to handle that in terms of time frame? I'd like to have 5 business days to be able to respond to the case law.
Well, the 20 days was from the order adopting my report, not from today's hearing. So I won't do my report until after I've considered the additional legal authority that you're submitting.
Okay, so do you want me to submit my own report and proposed report and recommendation also, or you're not going to handle it completely?
I'm going to ask you to submit a proposed report and recommendation because unless this case is very clear that it could not possibly be trade secret, I think the default is that the court has to do an in-camera inspection. So,
yes, sure.
You know, if you read that case, Mr. Falatek, and it's so clear that you're willing to withdraw your trade secret assertion, then you could do, maybe y'all could agree to a report where you're withdrawing it and then you're going to produce the documents. But absent an agreement, then I think the in-camera inspection is the proper procedure.
That's fine. I just wanted to make sure. So what I'll do is I'll send in a proposed report and recommendation that's at least been reviewed by Mr. Stewart. And then when I do that, I'll also send in the supplemental argument regarding the case that Mr. Stewart cited. And then Your Honor will have all that together. Does that sound agreeable?
That's agreeable. And if Mr. Stewart really wants to submit a competing proposed report recommendation, he's welcome to do so. But
I will what counsel provides, and if it's acceptable to Your Honor, I will just point out any commentary or disagreement I have to that to not make multiple reports.
I usually like to receive those in redlined versions so that I know what the specific issues are and what your proposed wording would be. And it's helpful to me in trying to sift through what's agreed to and what's not agreed to, or at least not opposed, even if you don't agree to it. I have a template. I know you're familiar with that process, Mr. Falatek, so I'm not going to repeat it on the record unless I have questions. I need questions from anybody, starting with Mr. Falatek.
No, Your Honor.
Mr. Stewart.
Oh,
I don't. So thank you, Your Honor.
And just for the record, because I know you haven't asked, but we'll reserve 10 days objection.
The exception period will be preserved, as I assumed would be the case. And then, Mr. Bendel, was there any other questions or clarifications today?
No questions, Your Honor.
Okay, I hope you all have a wonderful day. Thank you so much. Take care.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, I heard 2:30 was canceled. I assume you already knew that.
Yes.
So that leaves 3 o'clock and the one that got moved to 3:30.
The guardianship.
Adela told you that, right? Well, we're only 2 minutes ahead of schedule. We do have one person in the waiting room. I will let her in now. Good afternoon. How are you today?
Good afternoon. I'm doing well. How are you?
Good, thank you. I know we're still 2 minutes early, but I don't have defense counsel yet. Is the motion still contested?
Yes.
Okay. Well, let's give them a minute to show up. And if they don't, then I will try to call them.
No problem.
It was set by defendant.
Mm-hmm. I will say we had internet issues at my office, so I came home just to make sure that I wouldn't get kicked out of the hearing because I had an issue this morning.
Okay.
And there's some kind of an outage, says our provider.
Oh, really?
Mm-hmm.
Is it William Cradaville that you've been dealing with?
Yeah, it has been.
Oh, okay. Well, still another minute. Were you expecting a court reporter?
I was not, and I don't know if the defense hired one or not.
Okay. There's nobody indicated on the certificate of service on the notice of hearing, but sometimes they send it separately. All right, I got 3 o'clock on my clock and nobody else in the waiting room, so I'm gonna call his office.
Voting. This is Alexa speaking. How may I direct your call?
Good afternoon. This is Magistrate Bocelli calling in open court for William Cradaville. He has not appeared for a 3 o'clock hearing today.
Okay, one moment. Municipal in Southwest Florida. This is Yasmin. How may I help you?
Good afternoon. This is Magistrate Bocelli calling in open court. We have a 3 o'clock hearing set by Mr. Cradaville, and he hasn't made an appearance. Oh, he just popped up in the waiting room.
I was about to say he should be getting on right now.
Okay, thank you.
Thanks. Bye.
Bye-bye. We'll give him a minute to connect. Maybe my clock is fast.
I had the same time. Although my dog thought she was going to participate for just a moment there.
Oh, I've heard plenty of dogs barking. All right. Good afternoon, everyone. This is Magistrate Bocelli. I've let in everyone from the waiting room. I believe we're all here for 20 CA 3335 Dendal versus Ace Insurance Company of the Midwest on defendant's motion to compel plaintiff's discovery responses and deposition dated March 31st, 2021. The order of referral was April 28th, 2021. This is being live streamed to YouTube in order to maintain public access to the court, so please keep that in mind. I'd like to get appearances from counsel, starting with plaintiff.
Maria Alimo on behalf of the plaintiff.
And for the defense? After unmuting yourself.
Oh, was I muted? I apologize. William Cradaville on behalf of the defendant, Ace Insurance Company of the Midwest.
Thank you very much. And I don't have a court reporter yet. Mr. Cradaville, were you expecting one? Ms. Alamo had already indicated she was not expecting one.
I did not order one.
Okay, so we have electronic court reporting as the official record of our proceeding today. I'll turn it over to defense counsel for argument.
Yes, Your Honor. This is a personal injury lawsuit that was filed on May 22nd, 2020. We have filed a motion to compel plaintiff's discovery responses and deposition. Just as a roadmap here, we were served with discovery back in June of 2020. We timely answered within the month by July of 2020 on everything, actually. And then we started in our process setting the deposition of the plaintiff. It was set to take place in October. That was pushed out. We also served interrogatories and request production upon the plaintiff in September. There was a conflict that came up with the deposition of the plaintiff. It was rescheduled to December, and then we were notified that that one wasn't going to work either. Basically because December 3rd, they filed a motion for protective order, citing that they had lost contact with the plaintiff and unable to respond to or produce her for deposition. it's never been set for hearing is the issue, Your Honor. So basically what happened was they tried to set that in front of Judge Laboda. Judge Laboda recused herself. So I didn't go forward, and we were kind of left with the position that, okay, well, we have these certain case management deadlines we entered into on December 1st. And we can't go into mediation without, number one, getting discovery responses, number two, deposing the plaintiff. And we're kind of stuck in this. Well, the defense is obviously very prejudiced because we haven't gotten any discovery. We haven't spoken to the plaintiff herself or issued subpoenas as we would normally do. So what we're trying to do is make something happen. We need something to go forward in this case, or the case needs to go away. It needs to be dismissed. So what we're asking to either compel the plaintiff for deposition and respond to discovery. Well, compel the plaintiff for deposition. Number two, compel them to respond to discovery with whatever time you feel is appropriate, 10 days. It's been months and months. This case has not been stayed. There is no motion for protective order that has not been abated. We're still plowing along and we're violating case management orders as we proceed. So we'd ask this court to force the deposition of the plaintiff, make them to respond to discovery within 10 days, and or make a limit as to when she can keep representing this individual until we can move for a dismissal. Thank you, Your Honor.
Thank you. Ms. Lamo, your response.
It has not been for a lack of trying on my end. What I foresee ultimately happening is that I might have to move to withdraw. The communication has been very spotty, and just when I get a glimmer of hope that we're going to get something done, we lose communication. So I would object to 10 days only because I can't get a hold of her. I can't produce someone I don't have. I can't give responses to discovery that I don't have. I can forward on the RTP end all of the medical records and documents that I have, but otherwise I need the plaintiff and her input, and she is currently MIA.
What do you propose as a reasonable time period, Ms. Lamo?
Your Honor, if I could have, well, if we could give the plaintiff 30 days, if I don't hear from her, I'm going to be forced to file a motion to withdraw. I don't have a choice if I can't reach her.
Any objection? And to be clear, my dates are calculated from the order adopting the report and recommendation. Any objection to 30 days, Mr. Cradaville?
What is it 30 days for, Your Honor? To either respond to discovery or file a motion to withdraw?
Well, my ruling would just be to respond to discovery. Now, she's indicated she would separately file a motion to withdraw if she wasn't able to comply, but I would not be ordering her to file a motion to withdraw because it's up to her.
Right. No, we would object to the 30 days simply because discovery was served back in September of 2020. There's been multiple attempts. There's not even a motion for extension of time. It's clear that this is 30 days isn't going to matter versus 20 days for us. I mean, it's literally been outstanding for months and months and months through no fault of counsel. I'm not passing judgment on that, but again, 30 days is what they got in the first place. Through regular discovery.
To be frank, the 30 days is so that I can try and find a way to communicate, to say, hey, there's an order. I absolutely need you to communicate with me. And if I can't get that, then I'm going to file the motion to withdraw. If it's 10 days, then so be it, and I'll take the appropriate action.
All right, now the motion was also directed to deposition. So I don't know that you've addressed that, Ms. Lamo. Do you have any objection to the court also ordering your client to appear for deposition within a certain period of time?
Only that I have no access to her currently, so as long as the court is not ordering me personally or my firm personally to produce her, because we've been doing everything we can to get her back in contact with us regularly.
Your Honor, I would ask that she be produced within 30 days after the production of discovery, because it doesn't do us any good to take her deposition without her discovery.
Right, you want the discovery first, right?
Correct.
So your proposal would be 30, so 30 days, well, I was gonna say 20 days from the order adopting to provide the written discovery responses that haven't already been provided. I believe that requests for admissions were answered. So we're talking about interrogatories and requests for production. And then you wanted it 30 days after that, Mr. Cradaville, was that your suggestion for the deposition?
From receipt of the completed discovery. I just don't want to come back and say, well, here she is, and
well, let me ask you this. Let's assume she's not going to give you the written discovery. Do you want to be able to have an order saying you have to appear for deposition within 50 days or 60 days, and then she doesn't appear, and then you have a CNA? Do you want that, or do you just want the written discovery or nothing?
That's fine. I agree.
I have no preference. I'm asking what you want from
it. Makes sense. It gives me the ability, if I don't get discovery within 20 days, and then 30 days past that, if we did get the discovery within 20 days, it'd give us 30 days to hustle on our end and get done what we need to get done. So 50 days to be produced to be deposed.
All right, I'm going to make it 60 days for the deposition, just to have a round number. So 20 days from the order adopting for written discovery responses that would include responsive documents, verified answers to interrogatories, and then 60 days from the order adopting to sit for deposition to be separately noticed by counsel for the defendant. I know Ms. Alemo might be filing a motion to withdraw somewhere in there if she doesn't get responses, but those deadlines could be, normally if there's a motion to withdraw, there's a stay period that would extend the time period, but I can't not rule on the motion because Ms. Alemo might file a motion to withdraw. So I do think it's appropriate to grant the motion, given that there have not been written responses to the discovery request, as well as the lack of a deposition. When we have a case management plan with deadlines coming up, I'll note that it looks like you've got some deadlines to disclose witnesses and facts, and actually the disclosure of fact witnesses already happened. That was April 18th for the plaintiff. Disclosure of expert witnesses is May 21st for the plaintiff. So, you got to comply with the deadlines or ask to extend the deadlines. You can't just keep in this limbo phase forever. So I think these are reasonable time periods to try to get the plaintiff to respond, and if not, to take appropriate action thereafter. So Mr. Cradaville, can you please send in a proposed report and recommendation that sets forth the findings today? Again, pretty basic. Motion is granted, 20 days from the order adopting to provide the written discovery responses, and then 60 days to sit for deposition to be noticed separately by your office. I'm not holding Ms. Alemo's law firm to, have to produce her if it's not physically possible, but I assume you will notify her of her obligations and do the best you can, and we will see what happens.
Thank you,
and
Your
if she
Honor.
doesn't comply, then there are remedies available under the rules that the parties may pursue.
Thank you, Your Honor.
So there is that exception period. You want to preserve that or waive it, Ms. Alemo?
I'll waive the period.
You will waive it. Mr. Cradaville, do you want to
We
waive
have
it?
exceptions, yes.
All right, so if you can agree upon the form of a report, I will most likely not make any changes to it. Please submit that by email with a Word attachment or upload it to the portal as a proposed report to my attention. And that'll be all for today, unless y'all have any questions.
That's it, Your Honor. Thank you.
Thank you, Your Honor.
All right, take care. I hope you all have a great afternoon. Thank you.
Thanks,
Thank
Tom.
you, you too.
Bye-bye.
Bye-bye.
All right. I'm going to take a recess and I will be back closer to 3:30.
3:30. Okay.
Thanks.